Morning, Council. This is the case of In Re ER. Before we start, a couple of notes. We have allocated 20 minutes to each side, and I understand that'll be split between the guardian ad litem and the state. It's our practice, however, to continue to ask questions as long as we have them. We want to make sure we appropriately educate ourselves, and this is our opportunity to do that. So that might mean that you will exceed your time. Don't worry about that. It won't cut into any rebuttal time, any extra time. As long as we're asking questions, please continue to respond to the questions, and you need not ask for leave to exceed your time. That may result in unequal time to each side, but that's simply a function of the number of questions we have with respect to your case. If we have a question, we'll raise our hand as to signal to each other and to you that we'd like to get in line. You don't need to stop mid-sentence, but please get to our sentence, to our question rather, as soon as you reasonably can. If we have technical difficulties, we'll take whatever time is necessary to ensure that you have a full chance to make your argument. Helps for bandwidth purposes if you mute when you're not speaking. And I think that covers everything. So we are ready to go. And we'll begin with council's appearances.
Margaret Lindsay, Utah County Public Defender Association, for the mother who was the petitioner.
Welcome, Ms. Lindsay. Good to have you with us.
Martha Pierce, Attorney Guardian Ad Litem.
Welcome to you also.
And John Peterson, Assistant Attorney General for the state.
Peterson, good to have you join us also. And we do appreciate your willingness, all three of you, to join us virtually here today. Okay, let's begin.
Your Honor, Margaret Lindsay, counsel for the mother. I've requested that 5 minutes be reserved for rebuttal. As a young appellate attorney, nothing concerned me more in working on a case than the question of the appropriate standard of review. Fortunately, I remember being given a copy of Judge Norm Jackson's article on standards of review, and that became like scripture to me. I think at some point I even diagrammed my own pasture under Pena and began placing issues around that pasture as I came across them. But as intimidated as I was then by the issue of standard of review, I think I'm even more terrified of this question today before the court, because what the appropriate standard of review is on the ultimate questions of termination of parental rights is that important. It's important to my client. It's important to all those who love ER in this case, and it's critical to every future termination cases. We have frequent conversations around my office on the criminal side about standards of review. We talk about them in our cases that are on appeal, and we talk about anticipated standards of review for cases that are still neck deep in the district court. But our conversations with our clients on juvenile termination cases is different. It goes something like this. Yes, you have a right to an appeal, but that's really all I can guarantee. You have a right to an appeal. I can't even guarantee that your case will be set for normal appellate briefing. And so far as having an opportunity for appellate court to restore your parental rights, or even to reverse the case or on error and remand it to the juvenile court, your chances are about as high as a pitcher hitting a home run in the World Series. It's just that rare. those conversations with our clients in the juvenile termination cases, I reflect the highly deferential standard of review that has been applied to the ultimate questions of termination, where if a foundation for the juvenile court decision exists in the evidence, then the appellate court should not reweigh the evidence, and that is sufficient. Whether that is the appropriate balance between judicial power and responsibility between this court, the Court of Appeals, and the juvenile courts is truly the question before this court today. Yes, Justice Peterson.
Ms. Lindsay, as a practitioner, can you explain, we always give deference for factual determinations to district court, so it's always going to be clearly erroneous. As a practical matter, what's the difference between that and the standard for factual determinations in juvenile cases? Just between the law and how it plays out, what do you see as the actual, what is the ground that you're arguing over? What's the difference there in how these standards of review kind of apply and in practice?
Are you asking me what my interpretation of what it is currently, or what I think it should be?
What it is. I think, what do you see as the difference between, in general, our deference to factual decisions made by district courts and all trial courts? And in this case, what is the real difference there that you have a problem with as it stands right now?
Well, if we're talking about application of fact to law, I think that's really the situation that we're talking about. I think on one level there is no difference, because there is no difference, or there should be no difference, and that is factual findings are always and should always be reviewed for clear error, with whatever inherent credibility decisions that accompany those factual findings afforded some deference. Where the difference, I think, comes into, and what is the ultimate legal determination of whether there are grounds to terminate parental rights, and whether there is termination is strictly necessary to the best interest of the child. And that's where I don't believe that this court's decision in BR truly makes a distinction. That's Justice Lee.
Let me ask the question this way. I think my question is related to Justice Peterson's. One of the things I'm trying to understand in terms of your position, your argument, let me start with this. Let's say, for the sake of argument, let's say that we conclude that the kind of mixed decision that's at issue in this case, that it's a fact-like mixed determination. I'm not saying that's what we're going to decide, but just for the purpose of my argument, accept that premise. One of the things I'm trying to understand is there any space between clearly erroneous, the standard that we apply to factual findings, and the standard that we would apply to a fact-like mixed determination? Because BR says must be against the clear weight of the evidence, or leave the appellate court with a firm and definite conviction that a mistake has been made. I think that's pretty well in line with, at least sometimes, how we define clear error for purposes of factual findings. And I wonder if you can help me with, do you disagree with that? And if we decide this is a fact-like mixed determination, are you asking us to treat the standard as something different than what we would apply to a factual finding? And I know your first order argument is de novo review, and we can get to that in a minute, but I'm trying to understand if there's a sort of backup position that even if we treat it as something that gets some deference, the BR formulation is too much deference or too far away from the way that the clear error standard is defined or something? I hope I'm asking a coherent question.
You are, and I think your questions reflect, the struggle, so to speak, and that this is a challenging, issue that I think all of us want to try and get as right as we can, as appropriate as we can. In looking at BR, I think Justice Lee, what you said is correct, except for there are a couple things in BR, and we're really talking about paragraph 12 of BR. Excuse me. One of the hazards of oral argument and allergy medicine is a dry mouth.
I'm with you. I'm in the same boat with you today, so I get it.
But there are a couple things in paragraph 12 that I think is reflected in cases since that time, and largely, we're talking Court of Appeals cases, which are at the heart of juvenile court original jurisdiction, is that the juvenile court should be given, it's the high deference. It's, deference beyond a factual finding is clearly erroneous. And there's also the question in the statement in BR after it talks about, whether the result is against the clear weight of the evidence or leaves the appellate court with a firm conviction that a mistake has been made.
Do you mind if I interrupt here for just a second? Because I want to make sure I understand something. I think what you just said a sentence ago gets directly to what I'm asking, at least if I understood it. So is your read of the standard we articulated in BR or the standard as it's been understood in Court of Appeals opinions, is your read that it's been interpreted as more highly deferential than clear error?
Yes.
And in what ways, but what specifically in BR strikes you as stating a standard that's more deferential than the clear error standard for factual findings?
In essence, it's the last sentence, which
of paragraph 12.
Right, paragraph 12. If I read the last two sentences where it says, therefore, in this case, the juvenile court's decision could be overturned only if it either failed to consider all of the facts or considered all of the facts, and its decision was nonetheless against the clear weight of the evidence. But then that last sentence says, when a foundation for the court's decision exists in the evidence, an appellate court may not engage in any reweighing of the evidence. And I can think of, I'd have to get the cites, but I recall reading over the last few days multiple decisions where the Court of Appeals decision hinged on that last sentence. Justice Pierce, Justice Lee, I don't want to interrupt to.
Yeah, I don't want to step on Justice Lee's question. If he has a follow-up or if you're still answering him, I'm just raising my hand to get in line.
No, I think I got it. I'm just looking at paragraph 12 of BR right now, but that's directly responsive to what I was asking and helpful. Thank you.
So let's say that we agree with you that maybe the Court of Appeals has read BR to require a higher standard and that it should just be the regular clear error, or if there's any daylight between that and what we do with a mixed question of law and fact that is more fact-like than law-like, and we apply that regular standard to this, not a heightened BR standard. What in this case? What did the trial court do? What did the juvenile court do that was contrary to the clear weight of the evidence? What findings would run afoul of that lesser standard?
The lesser, you mean clear error? You mean so just
clear error? Yeah. Assuming that BR is a heightened standard, and if we do it under the regular lens,
here's the issue. I don't take issue with the trial court's pure factual findings. I mean, I think is pure factual findings are supported by the evidence. What we are arguing is that his application of those factual findings is what is against the total clear weight of the evidence as to the question of whether termination is strictly necessary to the best interest of the child. Particularly when you look at the public policy contained in our statute, in the termination statute, largely 78A6503, as well as the requirement now that termination be strictly necessary to the best interest of the child.
Can you articulate for me how the trial, how the court erred in this instance? What in that finding was against the clear weight of the evidence?
Well, yes, our position is that the court based its decision that termination was strictly necessary to the best interest of the child, largely on the child's court exhaustion, so to speak, and understandably so. But that ignored several other important facts, especially concerning the bond with his mother and how his age and how the relationship and the current parent time with his mother was beneficial to him. Didn't consider really her the steps she had been taking and working on, and it also was. It's a factual finding that is not legally, I suppose, I think possible. You can't termination of the mom's rights. And if the court recalls that the dad's rights were already terminated in this case, and he did not appeal, and 19 pages of juvenile court's decision were really based on him. But simply terminate the mother's rights does not guarantee that there will be no specter of future court for the child, any more so than not terminating the rights would make the specter of court a probability rather than a possibility. The other thing about best interest, and I think this is, and I wish I could claim this thought, but it came from speaking with some other attorneys in a case, JL, that has just been certified to this court, and a brief will be filed shortly, that, especially when we're talking about best interests and whether something's strictly necessary to that child's best interest, we're talking about present, but we also have to think about the future. And position is that when you look at that through that lens, that the fact of the court exhaustion, and look, there are other facts. I mean, child's needs, child's relationship with his foster family. I mean, the fact that there had been, prior DCFS involvement, although I think it's important to note that in this case, this particular case originated when the mother and professionals felt like the child needed the state hospital, but the father wouldn't approve. But, looking at future needs, our position is that the juvenile court's decision although his factual finding is accurate, simply cannot legally establish that termination is strictly necessary to the best interest of the child. And one of the concerns that I think all of us have that practice in the juvenile court is that termination is the equivalent of a one-way street where there is, in general, no way to get back to the position before. Whereas the juvenile court at least should and consider, and I think this is one of the things that's really behind some of the policies from behind BTB and the Court of Appeals' decision since then, that the court really should, in order to assure that termination is strictly necessary, be looking at what the feasible alternatives are. And in that situation, something short of termination, in my opinion, becomes almost the equivalent of a four-way stop, or maybe even better, a roundabout, where there are other places that you can go in terms of, evaluating needs and best interests and whether something's strictly necessary, including getting back around to the question of termination, down the road.
Thank you for that. I think that gets a little bit of the question I was asking you. Is it your position that the court did not look at alternative options to termination to decide it was strictly necessary? And where in the record do we see that?
Well, in the record, if I recall, and it came up at the close of the state's evidence. I think that counsel of the mother had started, inquiring about options of permanent custody and guardianship. And then it was basically argued, I think initially by the guardian ad litem, that is not the issue before this court. The trial court agreed and basically said that's a question for another day. The only question before this court is whether rights should be terminated. Did that answer your question, Justice Pierce?
But Ms. Lindsay, the trial court in its findings and conclusions did specifically conclude that it was strictly necessary. And it did so based on findings taking place around findings, right, 52, 53, 54, around there, that this particular child required permanency, and the permanency couldn't be even the specter of additional proceedings that would accompany a permanent guardianship was too much for this particular child, even if those proceedings didn't take place, right? It used the noun specter. So I hear what you're saying about what was argued, but the court does specifically seem to have addressed both the factual underpinning and the legal requirement in its findings and conclusions. Am I wrong?
Well, that's certainly what the Court of Appeals concluded.
I'm not looking at the Court of Appeals. I was looking at the actual findings and conclusions.
Right. Well, our argument is, in fact, there is a pending petition, by grandparents as well, that still to this day remains pending. Is that without truly looking at those other options, how can you truly make the determination as to that? When
the question I have for opposing counsel, I agree with you. There may be something to be said here, and this is just kind of a heads up for opposing counsel, right? The court based it on the specter of this, but that's kind of just speculation versus, a possibility would be to try this on a permanent guardianship basis and see if that stress still exists when there is a permanent placement for the child. And none of that was considered. It was just at that time a decision was made, well, that this seems to meet a potential risk, and so I'm going to do away with it. And whether that truly complies with the strictly necessary prong.
Yes.
That was more.
I would agree, and that's. I mean, I think our point and our concern is that talk of the specter of future court is not something, whether there's adoption or permanent custody and guardianship, that is anything more than speculation.
Could I ask you a question about this? Because the thing that I'm struggling with is the question on which we granted certiorari is just whether the Court of Appeals applied the correct standard of review. And the argument that you've made in your brief, I think, you could correct me if I'm wrong, goes purely to the assertion that we ought to be applying a de novo standard of review with respect to these kinds of, decisions about termination being in the best interest of the child. That's all we have before us, isn't it?
I think that's correct. I mean, that is the issue before this court, and I think that after trying my best to think through this issue and argue it, I think that is the correct standard of review. Yes, I could see how you could say that there are some fact-like elements to this decision, but there's also some fundamental legal issues that are at the heart of these decisions, that implicate constitutional and fundamental protections. And I think that really under both Sawyer and Levin, that the public policy arguments and the public policy of the state, including the section that is put in the Court of Appeals and in the Judicial Code about appropriate standards of review that consider these fundamental issues, combined with the fact that just on the plain language of the law, I think that whether something is strictly necessary to the best interest of the child is law-like as well, and that even on cases where they may initially appear to be more fact-like, this court has still, whether it's in the Fourth Amendment or the Fifth Amendment, looked at it and said, there's an importance to uniformity that I believe in Sawyer. Let me see, I think I've got that quote. This court says, "We have not retreated from exercising de novo review of equally fact-intensive matters that arise in the realm of search and seizure. We have not ceded deference in these cases, both because they concern constitutional rights and because, irrespective of the difficulties inherent in extracting general rules from fact-intensive matters, we nevertheless believe it a worthy endeavor to offer guidance to law enforcement officials charged with the duty of conducting their affairs within constitutional bounds." We believe the same that applies to the juvenile court. And I don't think, my belief is that this court's decision in Brake as the Fourth Amendment, and such as reasonable suspicion, or the Fifth Amendment, such as custodial interference, has not changed the balance really of the number of cases that are reversed or not. But what it has done over the course of the last 10 years is to offer some strong guidance to law enforcement, to prosecutors and defense attorneys, to district court judges, that these issues are important. They're important that we be careful about them. They're important that we be precise about them. And that has only, I believe, increased the quality of review and of cases on all levels. And the
So-
same would hold true for the juvenile court.
Ms. Lindsay, I may be missing something, but as a follow-up to Justice Lee's question, you did suggest you wanted supplemental briefing once the standard was established, but then you spent 10 to 12 pages just arguing that the Court of Appeals, I mean, basically arguing the Court of Appeals and the trial court got the strictly necessary language wrong, right? I mean, what's all that discussion from pages 36 on if it's not about that the district court didn't properly consider or apply the strictly necessary prong?
You know, it was a combination. It was a combination of two things. One, there is the question of whether or not the juvenile court adequately explored the feasibility of alternatives.
Yeah, and all I'm asking is, it seemed to me, whether it is or isn't part of the question that was requested, I take that point. There's a lot of briefing from both sides on that issue.
You know, the second thing, and I think in terms of pointing out and really looking at some of the other cases, was to establish that also that we believe that.
I'm not being critical. I just want to understand if that's an issue you're maintaining now.
No, I really, it would be my request. You know, and for, in part because this is a big question that's before the court and a difficult issue. And I know that I can do my best to try to argue what I believe the answer is. But ultimately, this issue and this decision it has to come from this court. Although I am more and more firmly convinced that the only way that a proper balance and between judicial power and responsibility on these critically important termination cases can be is to adopt the same, standards, that kind of prong standard that was done by this court in, Thurman, Brake, Levin, and that is we review factual findings for clear error, and the ultimate questions of whether or not termination of parental rights is strictly necessary to the best interest of the child, including, grounds of establishment of unfitness, is reviewed for correctness. Now, understanding that those factual findings are still subject to a clear error standard, and understanding that some of those, with credibility determinations are still subject to some deference. I see my time is up, and if there are no questions, I will turn the time over to somebody else.
Thank you, Ms. Lindsay. Let's see, Mr. Peterson or Ms. Pierce, whichever you've decided you want to go first.
Oh, here I am. Okay. May it please the court, Martha Pierce, attorney guardian ad litem for the minor child. Ms. Lindsay's wants to analogize this case to a search and seizure case, and I submit that that's an impossible thing to do. Search and seizure, it's a discrete point in time, and it's one person's constitutional rights against the state's. And in juvenile cases, it's often a years-long process where the court visits and revisits what happens. And it's not just one person's rights, it's also the child's rights. So something as simple as relative placement. Well, the law requires the court to go back and revisit that question. You look at it at the shelter hearing. The court has to order the parents that within 5 days they have to work with
Ms. Pierce? Ms. Pierce, so one of the arguments that resonated with me that was just made was that the last sentence in the standard set forth in paragraph 12 of BR may have gone too far, and that courts have been relying on it. So as we've been sitting here, I just took a quick look at our case law and see that there are about 176 cases in this area that quote that language. Now, I've not gone through them all, but so far every case I've looked at, it's just been an affirmance. I mean, maybe the lower court got it right in every single one of those cases, but is Miss Lindsay right that as a result of that statement, and we've put our Court of Appeals in a position that it's almost impossible to reverse?
I think that this case is like any other case, that if you raise a sufficiency of evidence challenge, that's an uphill battle. You're hardly ever going to win that case unless there's evidence missing on one element. But otherwise, the majority of
But it's not just a sufficiency, right? It's well, I mean, it's really taking, even if we were to take the facts as granted in every single case, when we apply those facts to the standard, because that standard is informed by that last sentence, the trial court was right in every single instance.
Well, when you're looking at the 154 or however many there are, some of those are sufficiency of evidence claims. Some of them might be the mixed law question. And then I think it is important for the court to ferret out, are there any embedded legal issues in there? But I think it'd be impossible for this court to do any kind of de novo review, since this is a year's.
Yeah, I'm not suggesting de novo review. I'm just wondering if the standard, perhaps we ought to take a hard look at that language in those cases and see if the standard does need some tweaking, and that we can take, I think we have a big enough data set that we might be able to draw some conclusions from that data set.
I think it'd be really difficult there's no more subjective question than best interest, because what is best interest for a self-sufficient 17-year-old is going to be very different than a medically fragile newborn. And it has to do with dynamics. It has to do with the court's observations of these folks over years. It has to do with whether the courts can see if this is an empty promise or the parents are sincere. I mean,
Sure.
there's so
all those reasons counsel for high deference. I get that, but you would have to agree that if we've written a standard so that it's effectively, King's X deference that cannot be overcome, that wouldn't be appropriate too.
That would not be appropriate, but where it does get overcome, and that's on my part too when I do appeals, is you have to find an embedded legal error. And that's where Ms. Lindsay she has mentioned some embedded legal errors. For instance, she wants to make best interest about the parents' constitutional rights, and BTB says, well, that's not so. She wants to make best interest about the 503 factors, and note 13 of BTB says that's not so. That the 503 factors have to do with fit and competent parents. So I think you do have to do high deference for a court that has been observing these families for as long as it has. So I don't see how you can revise that language. Yes, Justice Durant.
If we were inclined to revise it, and I'm not saying we are, but I'm wondering whether a better standard might be if we simply stopped in paragraph 12 of BR with against the clear weight of the evidence. Maybe it's the next sentence that's problematic.
Yeah, that may be.
When it says when a foundation for the court's decision exists, that could be read as any foundation or in any evidence standard almost. I just wonder if that's where the imprecision comes in and the bar gets raised too high.
That may be so, although I can't think of any case that would turn on that language being in or out of the standard, because I believe that both appellate courts have really been applying the clearly erroneous standard, which comes from Rule 52. And BR really is built on NRA ZD, which is which came out, I think that's 2006-54, and that looked at Rule 54. It looked at the U.S. versus Gibson case. This is an age-old standard that we use. So it could be, I mean, it could be that language you're talking about has been misinterpreted, but I can't think that any case has ever turned solely on that language.
Thank you.
Did the Court of Appeals in this case cite that language? Because that sentence jumped out at me as well. And that when Ms. Lindsay mentioned it, I looked back at the opinion, and that sentence taken out of context, I think could be problematic. Did the Court of Appeals in this case cite that sentence about if a foundation exists in the evidence, the appellate court may not reweigh?
Did not, but I can tell you that I don't believe that there's any way to interpret that the Court of Appeals opinion turned on that language, because I think in this case it was so clear that this mother has such a toxic relationship, and even her solution that we just not tell the child about ongoing litigation. I mean, that's emblematic of her pathology to just freeze the child out. So I think that the evidence is overwhelming that this is not a mother who can be trusted to exercise any kind of parental ties, to exercise her parental duties. She just cannot do that. And so, and to maintain parental rights gives her the leg up, because then any kind of contact is rights driven rather than best interest driven. So if there are no questions, then I will give it over to my colleague. Thank you very much.
Thank you, Ms. Pierce. Mr. Peterson.
All right, am I back?
Yes.
May it please the court, John Peterson for the state of Utah. I guess I see kind of where the questions are going, and I'd just like to start out by noting that, you know, I mean, it's a truism, but juvenile courts aren't district courts. They're quite a bit different. As Ms. Pierce noted, the amount of time that a juvenile court judge spends with the parties is vastly larger than what a district court judge spends. I mean, you have starting from the shelter hearing, multiple shelter hearings, review hearing, dispositional hearings. I mean, oftentimes review hearings every month, at least every 2 or 3 months. I mean, the juvenile court spends a lot of time with these people up into permanency hearings and then a trial. And so, I mean, I think there's a reason why historically juvenile courts have been afforded that little extra leg up in degree of deference, is because they have.
There's a difference between a little extra leg up, and if our standard is effectively negating the roles of the appellate courts, right? I mean, you're right. I mean, I totally understand why deference is appropriate here. I just want to explore whether the standard we've articulated may not be being interpreted in such a way that it's gone too far. I mean, I don't think any of you would argue that we should be relegated to a rubber stamp here.
Oh no, I certainly wouldn't think that. I mean, I had a response to some of your questions too. I mean, you noted how you don't seem to see a lot of reversal from juvenile court, and I think there are reasons that are not just the fact that appellate courts are rubber stamping it. I mean, for one obvious thing, like criminal cases, the vast majority of the litigants in juvenile court have appointed counsel. When you have appointed counsel, there's no particular reason not to pursue an appeal in every case. You don't have any financial stake in it, and so why would you not? I mean, and so I think a lot more frivolous appeals are being taken from juvenile court cases because there's no reason not to take it, frankly. And I also would note they're a little bit self-selecting, and I don't think the state is pursuing cases that are really marginal. When you have parents who are stepping up and doing things and becoming better, those are the kind of cases where oftentimes they are resolved through even return home, permanent custody and guardianship, other kinds of situations that don't require more heavy-handed resolutions by the courts. I mean, I think there's a reason why you're seeing not that many reversals, but there are reversals. I mean, clearly they happen in cases. Yes, Chief Justice.
I don't want to step on Justice Simones's. You're okay. Okay, thank you. In reading the briefs, I didn't get a very good handle, and I hope you can help me on the role that, if any, that a potential placement with the grandmother played in these proceedings?
I mean, it was something that was kind of out there, but I mean, but really nobody was looking. I mean, it wasn't. I mean, I don't think you can really fault the juvenile court because no one throughout the cases. I mean, the parent mother wasn't proposing that as an option. They were really just arguing about whether or not. I mean, initially she was arguing that she had become fit, which I mean, she's now conceded in fact was not the case. But the alternative then was whether it should be permanent custody and guardianship or termination. I mean, it just wasn't something that was placed in front of the juvenile court. So I really don't think you can fault the juvenile court for not considering something that no one proposed to it. I mean, and it's also worth noting. I mean, what the foster parents in this case are truly somewhat exceptional. I mean, they took a child who was placed in the state hospital. They went and visited him multiple times in the state hospital to allow him to kind of become familiar with them. They took some extra specialized training to learn how to care for his needs. And they really have gone the extra mile. They've done everything, including facilitating, contact with his siblings and his mother to the extent it's appropriate for him. And they are clearly people who are looking out for his best interest and what he really needs in this case. And I think that goes to the question of why the juvenile court's decision was so appropriate. I mean, there was at one point in time the foster parents that said, maybe we should not have him see his mother just for a little bit to kind of so he can settle down and kind of get used to being here. But they took Dr. Cotter's report to heart, and they said, no, he should do what he wants to do. And basically the position was like, ER, if you'd like to see your mom, you can see your mom. If you'd like to see your dad, you can see your dad even. But but they're the adults in the room. They're the people who are going to protect him from going down this rabbit hole of abuse he's experienced his whole life.
Why not test permanent guardianship as an alternative to termination?
I mean, I would argue that his whole life has been a test and that his mother has failed it miserably. I mean, it's 8+ years.
But in finding 53, the district court was actually complimentary of the mother and the continued relationship, and that it was beneficial. So, I mean, the court clearly thought that contact was appropriate, right? But that with the termination of parental rights, that can come to an end whenever the now the parents, right, the legal parents want to. But if there was something short of that, right, so there was the permanencies in place through a permanent guardianship, what's the problem with taking 6 months and seeing if that works? How do you conclude that it's strictly necessary without doing something like that when that argument was specifically raised?
I mean, I think they're basically, I think everyone agrees, including the juvenile court, that continued interaction with his mother is beneficial. There's two ways that can occur. There's through a permanent custody guardianship and through termination. Obviously, in termination, that occurs under the supervision and at the will of the foster parent.
Right.
With the permanent custody and guardianship, there are still legal enforcement mechanisms for the mother to come back in if she's not happy. If she decides she's just satisfied with what's going on,
the mother could continue that request, right? She's got a legal hook to ask for that continued visitation, which the court found beneficial. She doesn't have it if it's terminated, if the parental rights are terminated. Do I have that right?
Yes. But I mean, I think what the court found is it's of those two options, having it's most critical really that ER just has an end to all this. I mean, it really has been his entire life. And I mean, and the court found, and the foster mother testified that she was not going to shut down his contact. I mean, I don't understand why that finding is also not entitled to deference as well. That was her strong testimony, and she, even after consulting with the experts, that's what she decided was best.
Don't get me wrong. I take your point about the foster parents here. I understand that. My point is they can. Yeah.
Yeah.
I would argue that is completely appropriate given the history of this case. I mean, having them as the gatekeepers makes a lot of sense in this case. I mean, just to protect him. I mean, he's gone through so much, and just to make sure that really it is over now. I mean, mean, we're not going back to court again. We're not going to be fighting about things. There's going to be no more litigation in ER's life. I think that, I mean, given this is somewhat a unique case, I mean, you often don't see children that have had this much litigation in their lives. I mean, the divorce, multiple prior DCS involvements. Yes, Chief Justice, I see you have a question.
Yeah, I understand that the last position of the would-be adoptive parents, the foster parents, was that they would allow visitation as long as they consider it to be in the child's best interest. Is that correct?
That was correct. And I believe her specific decision was that she would, largely leave it up to ER himself. Are you feeling like seeing your mom today? Do you want to see your dad? Do you want to see your siblings? And it's like, because I mean, at some points in time, he did want to see his mom, and sometimes he didn't. I mean, it's not like this is something he looks forward to every week, and I need to go see my mom right now. He has some ambivalence towards that, and I mean, the mother's own expert, Dr. Cotter, didn't even come out and say that this is something he needs. She said it probably wouldn't have hurt him. It would be not detrimental. I mean, that's not exactly a determination that he absolutely is going to fall apart without any contact with his mom. I don't think the evidence supports that. I think it does support allowing him to have contact with her as long as it continues to be beneficial to him. And the best person to determine that in this case is his parents. I mean, the juvenile court can't stay in this forever to monitor the parties and see what's going on.
Can I jump you back to the standard for just a second, Mr. Peterson? Is it the state's position that In Re BR does not impose a higher degree of deference than we normally apply to factual findings on appeal? And if so, is the state confident that it has never argued in front of the Court of Appeals that BR imposes a more deferential standard?
I mean, we have consistently argued. I don't know how many cases there are. I mean, but there are dozens at least of cases that basically do say that juvenile courts are actually afforded a slightly higher deference. When they talk about the juvenile courts, specialized training and experience, and the fact that the court has greater familiarity with the party, and the things such as credibility determinations and witness demeanor are even more, profoundly, relevant to the juvenile court concern. I mean, so I think we've argued a lot of times that there is actually a slightly heightened deference which has been applied to juvenile court judges, and we continue to believe that is, and as I already started out arguing, that is, they are sui generis. They aren't district courts. They're different in the way they interact, and it is appropriate that they even get a slightly higher degree of deference to their decisions, given their long time experience with the cases and training and experience. And I think BR does reflect that.
Well, how would you? And maybe you'll just endorse the BR standard, but how do you think we could best describe this, what you've described as I think, slightly higher level of deference that we give juvenile courts, and in particular in these parental termination cases?
I mean, I think BR does a good job in, they quote State XRL ZD, and where it says, that we must forbear the close call. And I think to some extent, what Ms. Lindsay's argued is really that she'd like to have appellate courts, as I said, not meaning facetiously, but kind of as a super jury. That if you don't prevail in the trial court, you get one more chance, and see if 5 people maybe will have a different opinion. And I mean, I think, I think it was Justice Simonis who had a question, or maybe it was you actually, Justice Durant, who had a question about whether any evidence standards. I don't really read BR as being, if there's any evidence supporting it, we'll defer. But I mean, I think there's certainly a reasonableness to it. I mean, if there is substantial, reasonable evidence that the court relied upon to make its decision, then the fact that you could find a handful of people, especially in a close call, where it's like, these aren't easy cases. I mean, these aren't easy decisions to make.
And you've just injected substantial into the standard, and maybe that'd be better if BR said substantial evidence that serves as a foundation. I recognize, I take your point that doesn't necessarily have to be read as any evidence standard. I guess my concern is that maybe it's just imprecise enough that it could be misread in some cases.
And, and if this court wanted to clarify and say that there was, substantial evidence or some kind of reasonable, I don't think that would be, obviously these cases are decided under a clear and convincing standard. So the quantum of evidence needs to be substantial. It can't just be a bare minimum, or else that would be, be a preponderance. So obviously you do need to have a substantial degree of confidence in the amount of evidence presented. And yes, I have used up my time. I would just say that I do believe the evidence in this case was substantial. There was a very solid, the court well articulated the reasons for its decision, and while there obviously is an alternative, a parent custody and guardianship, the juvenile court just simply did not think that really provided this particular child, given his unique and storied history, with the true degree of permanency that he really needs and deserves. He's a very damaged child, and a lot of that damage has been caused by these years of litigation and acrimony in his life. And so he's not any child. He's ER, he's unique, and the juvenile court has unique experience with him. And as I use my time, I would ask that this court affirm and retain the appropriate deference which has been given to juvenile court judges over the years. Thank you.
Thank you, Mr. Peterson. Ms. Lindsay.
Thank you, Your Honors. No, I first want to say that, ER is unique and he is special. And so are all those who love him, grandparents, mom, siblings, foster parents. And although there's, there may believe different things, I would not or could not question the motives of anyone involved. But I think that goes in part to the heart of how important these juvenile court decisions are in termination. And really the question of how far the deference should go, whether it should be to the factual findings under a clear error standard, like we talked about, or whether it's, it goes to the deference, goes to the question of whether it's been proved by clear and convincing evidence that there are not only grounds for termination of parental rights, but that termination is strictly necessary, the child's best interest. I'm going to make just a couple other quick things. One is that the case ZD from my reading was really a Rule 52 case about factual findings only. Second, as far as the guardian ad litem's questioning my client's pathology, I suppose in the statements that she's referring to in the brief, it's not my client's pathology that is at issue, it's my own. And that was simply as a means of saying, there are a lot of ways that juvenile courts can look at permanent custody and guardianships and how they structure them and how they structure parent time. And, make no mistake about it, that the juvenile court did find that the relationship with ER's mother was beneficial. And, there was testimony that mom had been on time, appropriate to all her parent time, always, there, and that it could be detrimental to his growth to cut off that parent time. But legally, termination does just that. And I appreciate the motives of and intents of the foster parents, for example, but legally, there's no guarantee that that beneficial relationship could continue if termination is granted. And
all right, Ms. Lindsay, sorry, interrupt you. Go ahead and finish that thought.
No, that's okay.
Was the choice here between adoption by the foster parents and a guardianship with the foster parents. Did you make any kind of argument with respect to other alternatives, specifically grandmother placement?
The plan was to do so, I believe, in speaking with juvenile counsel. But and to probably more fully talk about even guardianship with the foster parents. But when the juvenile court at the close of the presentation by the state basically said, guardianship isn't at issue here. That's an issue for another day. The only issue is termination. I think that they felt that shut that inquiry down. The last thing I want to say in speaking with some other attorneys this week, they had done a survey and of juvenile, and this kind of goes to Justice Homonis' point. I believe had done a survey of child welfare cases, and I think termination cases in particular, over the last 10 years or so. And 96% of those cases were affirmed. And that's not all of the cases, because that doesn't include the cases under the child welfare rules of appellate procedure that don't get to briefing or don't have opinions issued, which adds additional cases. From a policy standpoint, one of my biggest concerns, and I think it's a concern shared by most practitioners in the juvenile court, is that under the standard MBR, as it's been interpreted and restated over the last dozen years or so, has rendered juvenile court termination decisions to largely exist in a vacuum or on an island. And that is why, in part, I believe that along with the other strong public policy and fundamental interests at stake surrounding families, not just parents, a two-part test for terminate the ultimate decision on termination is the appropriate standard to review for this court to adopt, with factual findings still reviewed for clear error. But the ultimate conclusion as to whether or not it's strictly necessary the best interest of the child should be reviewed, de novo.
Before you sit down, could I ask you one other question? I'm trying to make sure that I understand your position in your brief. This goes to the part of your opening brief that has the heading review of the Court of Appeals decision. Yeah. And you say there, without having guidance from the court on the appropriate standard review, it's difficult to craft an argument concerning the accuracy of the Court of Appeals decision. And then you mention the possibility of supplemental briefing or remand, and then you say nonetheless, and you proceed to make some arguments. One of the things I'm trying to understand is, are your arguments for reversal in this part of your brief premised on the idea of a de novo standard of review, or are they premised on the idea of a deferential BR-like standard of review or something else?
I think that they were largely premised on the idea of this is what I do know, concerning the correctness of whether or not, there was even under a pure legal standpoint, whether or not, in part, whether or not the feasibility and whether or not the juvenile court adequately considered everything that it needs to consider in making the conclusion. But it also was, I think, to take a stab at trying to make that argument towards, more, I think, of what I was hoping for, but frankly, not really knowing then or now which way this court wants to go. I'll admit to being to struggling. that.
Yeah, that's the confusion I'm having in reading this part of your brief. Is it's just not clear what. I know your main argument is de novo, treated as law-like. What I can't tell is what your backup argument is, whether it's what standard of your review
And that
you have in mind when you're making your backup argument.
and that in part is because I'm not sure, given the nature of the public policies, given the constitutional issues, given what I view just to be the importance of these decisions. I mean, and the importance that they cut to the foundation of, in a lot of ways, who we are as a people, and the import that we place on close relationships, that I can't see, and given what I perceive to be almost the lack of the ability to review these cases, and to look at it, from as a broader perspective. For example, in the JM case, each judge decided that, hey, we may look at these individually different. We may have reached a different conclusion, but the foundation's there, the high deference is there. We can't do anything. That I can't come up with a backup. I hope that is beyond what I have been able to do. Everything that I read, every time I throw this around with others, that's simply the conclusion I reach. Thank you.
Thank you.
Further questions? Appreciate it.
Thank you, Ms. Lindsay. Ms. Pierce, Mr. Peterson, we very much appreciate the briefing in this case, as well as the oral argument here today. And we'll take this matter under advisement. We're going to take a brief recess at this point. When we return at 11:30, we'll hear the case of Arnold versus Workforce Services. Court is in recess.